Well, good afternoon, everybody. My name is Chen. Welcome to the Samfiru Tumarkin live employment law show on Facebook and YouTube. I am a lawyer located at our Vancouver office. We have offices in Toronto, Calgary, and Ottawa as well. I will be here for the next half an hour or so answering live any questions to do with employment law, anything going on in the workplace, anything to do with, I mainly deal with non-unionized environments, but if you're in a union, feel free to pop in your questions here as well. If you just type in your question, I'll be able to see it on the text box in front of me here. So anything to do with, being let go, employment contracts, the hiring process, any issues you're dealing with in the workplace with your boss, with a fellow coworker, anything and everything to do with employment law, I can try to help here. So please put in your questions and I'll do my best to answer. Um, it's been a while since I've done my last Facebook Live. It's probably been a month. I've been away on vacation, but last time I think I talked about medical leaves and what to do if you're, sick or if you have a surgery coming up, and the rights that you have, if you can't work because of a medical condition, whether that's physical or mental. This past month, I've dealt something that's come across my desk more is this issue of bullying and harassment in the workplace. And so, oh, we've got a question here. So for everyone that's here, I will give priority to the questions. I'm here to talk about certain topics, but please feel free to cut me off. So I'm just going to jump into this first question we got here. It's from Anita. Can an employer refuse merit increase due to vaccination status? Had the performance review, they're not giving me a merit increase. And yeah, that's a very good question. I would say that there's certainly an argument to be made that that's discriminatory. When I say that there's an argument to be made, it's the grounds you would have is if you can't get the vaccine because of a certain medical condition, right? Or because of your religion or something that's protected under the Human Rights Code, then arguably your employer is denying you a benefit because of a protected ground. And that could be discrimination under the Human Rights Code. So, I guess it's really dependent on the reason you're not getting the vaccine, right? If it's just personal choice, you don't want to get it, which is fine. I'm not sure that the employer is obligated to give you that increase. It also depends on if you have a contract too, right? If the contract says like, hey, if I hit XYZ targets, I get a merit increase. That's different. Where it's more discretionary, where the employer is kind of saying, well, some people get raises, some people don't. That's a harder case to make. So I think you have two grounds of attack there, Anita. If you want to kind of follow up on your question, please feel free. You can say that it's if you're not getting the vaccine due to certain protected grounds of the Human Rights Code, that's number one, right? Number two is if you have a contractual right to that merit increase, right? Like you did what you needed to do to get that that pay bump. So yeah, feel free to follow up with more questions if hopefully that helped. So as I was saying, an issue that's come across my desk more is this issue of bullying and harassment. There's that recent story with the Vancouver Park sport person who who felt compelled to complain in a public forum. I think it was at a council meeting, that he had to raise the issues of a toxic work environment, of bullying, harassment in the workplace, and it obviously made the news this past week. that's obviously one way to go about it. I think just so everyone's aware, every employer in BC has a duty to implement a bullying and harassment policy in their workplace, right? It's not optional. You have to have some sort of policy to deal with bullying and harassment. So that before you kind of go to um, before you take any other steps, you go to the policy first. You see what the process is for raising bullying and harassment in the workplace, right? A lot of them will say you have to make a complaint to your, to the HR department, right? A written complaint, and then the employer has a duty to investigate it. They have a duty to kind of, resolve the bullying harassment, whether that's by warning the harasser, or kind of removing the person who's been harassed, the victim, from the situation. And so, if your employer doesn't have a policy, that they're probably not compliant with employment laws in BC. So the reality is, practically speaking, I find making complaint to the employer doesn't always resolve the problem, right? Especially if it's against a manager, right? A lot of times, the HR person or the person doing the investigation is going to be, generally, I don't want to say always, but biased, right, towards management. And so, especially if you're filing a complaint against your manager, it's going to be, the investigation that might turn out might not be the result that you wanted, right? I think the most important thing people can do, if you're experiencing, bullying harassment in the workplace, is you've got to keep your own written log, right, of things that have happened. Today is July 21st, right? Thursday, July 21st. At 10:05 a.m. Mr. Manager said XYZ to me, right? Just contemporaneous notes to kind of help keep track of, or at least kind of put in writing and have some evidence of bullying harassment. And so if the complaint to your manager doesn't resolve the issue, about the bullying and the in the workplace, the next step is kind of just to really think about whether you can stick it out there in that work environment, right? And if you can't, we've got some questions here. I will, like I said, for everybody who's here, I'm going to put priority to the questions, so please feel free to cut me off anytime. So we've got a follow-up from Anita. It's a personal choice for not getting it. Every year you receive the merit increase, 20 years with the company. Yeah, Anita, I would say that the way to go about it is to say that the merit-based increase is part of your contract, right? And they've breached the contract now. And so I don't see what, I mean, if they can tie your vaccination status to somehow your performance, I mean, maybe they have some sort of defense, but yeah, I certainly don't think that they should be using your vaccination status as a criteria, right, on a performance merit-based salary increase. What you can do about it is a trickier question, right? Because are you really gonna, it's something you might be able to bring to a court, right, and say, hey, Mr. The employer is not giving a merit increase, and therefore you suffered financial loss, right? I talked to a lawyer about it, see if it's worth it. But if it's a personal choice, I think the only way to go about it is say there's been a breach of contract, right, and prove that you suffered obviously the financial loss, the loss of the merit of the pay bump. But generally, I'll say that the employer, the unfortunate reality is they're not obligated in general to give people pay increases, right? It's kind of more of a discretionary, if we feel like it, we'll give you a pay bump. Very rarely will there be something in a written contract saying, yes, based on performance, we are going to give you a merit increase, right, every year. Okay, so we've got a question from Carrie. Can your request for vacation be canceled a day before it was initially approved and now has been retracted? Yeah, Yeah, I mean, Carrie, that's a good question. The Employment Standards Act, which governs vacation, as far as I know, is silent on it. The employer has wide discretion for scheduling vacation. Um, if you can prove that you're going to suffer some sort of loss through it, that might be a claim you can make against the employer, right? But they have pretty wide discretion over vacation days. But if you have an agreement for a specific vacation, right, and now they're retracting that agreement for that specific vacation period, then technically no, they can't just unilaterally retract that. The question is what has that caused? What loss has that caused to you? Um, Paul, can you refuse a deposition from your employer's lawyer? Would it be ill-advised if I did? Yeah, Paul. So it sounds like you're part of an ongoing lawsuit. Um, you're using the word deposition, which makes me think you might be in BC. It's called examination for discovery. Well, it's called that in a lot of Canadian provinces. If you're American, I'm going to refrain from advising. But if you're in BC, you can't refuse the deposition if you're suing the company, right? It's they have, excuse me, they have a right to discover you, or by right, I mean they have a right to sit down with you for a few hours and ask you questions under oath about your claim. And so if you don't, your lawsuit could be dismissed in BC. So I would say yes, it would be ill-advised if you refused. Yeah, Paul, you're in Ontario. Yeah, you're don't. It would be ill-advised. The same in Ontario, right? Your lawsuit probably would be dismissed if you're refusing to attend examinations. We've got a question here from JC. Is there a way to get severance from a local office um, while possibly being open to work with them at sites in other provinces? You work for several companies, and I found out that recently no one that one no longer has the contracts that I work under. Um, Sorry, JC, I'm still trying to figure out your question. So you're trying to get severance from a BC office. Um, are the several companies, are they related, or are they completely separate arm's length entities like corporations? Or is it kind of just like how, I don't know, or is it all the same business? They just have several different corporations. Um, because it goes to the question of whether it's a common employer, JC. Um, if they're different companies, different businesses, completely unrelated, I don't see why you can't get severance if you've been let go from the BC right company, um, and you're working for other companies in other provinces. If it's one company with several branches or a branch in each province, um, and one of them has no more work for you, then your employment relationship, or I don't know what relationship you have, but if you still have an employment relationship with the other branches, um, then I'm not sure that you can claim severance, right? It sounds like a complicated situation, JC. I would seek some advice one on one about that. You come talk to me. Um, if you want about it. But if it's just a matter of you losing some work from one office, then that also goes to the question of, has your pay been reduced, right? Because if your pay gets unilaterally reduced by a certain amount, you can claim for severance from the company. But if they're all interrelated, if they're all related companies, it's just one employer. So legally, it's called a common employer. Um, I'm not sure that there's a way to get severance while still working for that same, quote unquote, common employer. Yeah, just feel free to follow up. So you're saying there might be branches, not sure. Yeah, I think JC, those are the answers we need to kind of figure out if you can get severance. My gut says no, right? If there's just branches of the same company, if you want to keep working with the other branches, but again, I think you need to look at the structure and the relationship between the different locations in the different provinces. Okay, so we've got a question from Flex. Got hurt at work weeks after surgery. You were told you weren't told or received any documents from your doctor. Work sends you a letter on a Saturday. Your benefits were going to and they had work accommodations for me, and they said that I was cleared by a doctor. They didn't even have work restrictions. So Flex, I'm sorry, I don't understand the question. So if you could clarify, so all I got was you were hurt at work, you had surgery, work sent you a letter saying something about your benefits and accommodations. So what's happening now, and what's the issue you're facing, and you've been at work for 2 weeks almost, and you've requested a work restrictions progressive plan. So a gradual return to work. Okay. Yeah. So feel free. So let me know the issue is, and I'll try to answer. So I think, unless I've missed a question. Oh, we've got one here from. So Flex, you're saying they sent you to work. You haven't gotten any news from the doctor. What's your question, Flex? Requested a restrictions work plan. Okay. So while we wait for Flex's questions, I will move on to the next one. Okay, so JC, back to you. You're saying you've never worked for other offices, but you almost moved east at one point. Yeah, so if I'm understanding your question, you're saying, well, I think JC, what you're trying to do is you're trying to get severance, and then you're going to move to another one of their offices, right? Is that the general, kind of generally what you're trying to do? Yeah, because I mean, Flex, if the BC office is out of work, or they've let you go, then you can get severance. Nothing generally, legally speaking, prevents you from working for that same company in another office in another province. Okay, so we've got a question here from Joseph and Anne. So I'll do Joseph first. Okay, so Joseph asks, what are the rules regarding overtime pay in BC? Am I still overtime? Yes. So construction employees are weird in BC. Your construction employees are covered under the Act, on the Employment Standards Act. They are not entitled to certain things under the Act. So one example I'm thinking of is termination pay, right? So most employees, when they get let go, will get a minimum of approximately a week per year of service, right? Up to a maximum of 8 weeks in BC. Construction employees, unfortunately, are not. The important thing to keep in mind about that is that's the minimum. I think a lot of the viewers here probably know that, generally common law is more, right? It could be 2 to 4 weeks per year of service. Could be as much as 24 months pay if you're let go, as I'm sure a lot of people on here know. So yeah, hopefully that answers your question, Joseph. Assuming you're in BC, Joseph, each province has very different well, I shouldn't say very different. Each province has their own employment standards legislation, which sets the rules, the minimum standards, and so other provinces might be different. Okay, so we've got question from Kat, who I know is in Ontario, but I'll try my best to answer. You're a law clerk, you work for a law firm, you're currently on mat leave, and your employer is advising that they will not pay you for your accrued vacation upon your return. It would just be an unpaid leave. Should you wish to take it following your mat leave, my contract does not stipulate my 4 weeks vacation. It simply states I have 4 weeks paid vacation annually. Please advise what needs to stand on re getting paid. Yeah, and I think if you're on mat leave, you're not accruing the vacation pay, at least in BC. I'm pretty sure it's similar in Ontario. So if you've been on leave, you wouldn't have accrued vacation pay during that, however long your mat leave was. If you had accrued vacation pay from before you took medical leave, then that would still that's just unpaid wages, right? And you would just use that when you take your 4 weeks vacation. So unpaid leave should have decided to take it following mat leave. If you have vacation time you want to use, and I mean that's your vacation pay or vacation time, right? The employer has the discretion to kind of schedule it when they want, but I think that in your case, if your question is why haven't they paid you out over the mat leave, it's probably because you weren't accumulating vacation pay during your mat leave. Let me know, and if that answers your question, or if I've completely missed the mark. But that's how I interpreted your situation. Okay, so got a follow up from Flex. If you weren't told by your doctor or received paperwork that I'm clear to go back to work, and I'm forced to go back to work, is this unethical? Yeah, so Flex, that's a really good question. If you're not cleared by your doctor to go back to work, they cannot force you to go back, right? If your doctor says you got to stay off work, just get a note, send it into the company. They have to back off, okay? It's not only unethical, but if they force a person who's medically unable to work to go back, that's a breach of the employment contract, right? That's probably discrimination under the Human Rights Code. So it's not only unethical, it's probably illegal. And so, Flex, if you're dealing with that situation, feel free to give us a call or give me a call, and if you're in BC, I'm happy to kind of chat with you about what to do. But as just the baseline, just know you don't have to go back, right? Especially if you're not medically cleared by your doctor to go back. Okay, we've got a follow-up question from. So Flex, you're saying your doctor cleared you, but in addition, work was dismissal. Yeah, Flex, I'm sorry, I'm still not getting your question. So if you could just clarify. So if your doctor cleared you to go back to work, what's and you don't feel ready to go back to work, or if you just need accommodations in the workplace, if you could just clarify kind of what the issue you're facing now is. All right, so back to JC. You're saying you're just trying to figure out if it was possible to get severance for BC, and then maybe one day work for them in NB or Ontario. And if my severance payments out there, it would also be based on 2009. Yeah, JC, I think if you get severance from them, your years of service are gone, right? So, for example, if you get severance tomorrow from the BC, well, because you've been let go from the BC location, and then next year you get a job in Ontario with them, your length of service is not, it doesn't cover the since 2009, right? It doesn't cover the employment starting 2009. It would just cover whatever that new start date is. So, and that's true whether you were to get severance or not, for the most part, right? If you get severance, it's crystal clear, right? Your length of service starts from the date of your new employment. If you don't get severance, it shouldn't affect well, if you don't get severance, there's a bunch of factors to determine whether that employment is continuous, right? And there's a lot of cases that have been litigated on that issue, right? Is you get fired from the company, or you leave the company, right, and then you go back to the same company. Does your length of service get recognized? That's a different issue. If you get severance, that the analysis is done, right? You don't get your length of service recognized for any future severance. Okay, so we've got a question from Melissa. Non-union, does an employer have a duty to accommodate an employee who cannot find childcare for a schedule change? They have given us 2 weeks notice that full-time will be now be working a week of nights every month. You're a single mom. Ask for accommodation, told that we do not do that. Yes, they do have a duty to accommodate you. It is a human rights issue, Melissa. So it's in the ground is family status, right? And so in BC, most provinces, they have a duty to accommodate you, and the duty to accommodate really depends on, well, number one, what you're asking for, right? And whether it's going to be, impose, the legal term is undue hardship on the employer. So they don't have to spend $1 million to accommodate someone, but if it's a simple schedule change, right, and they have other employees that they can move around, or not move around, but if they have shifts available for you that can accommodate your childcare schedule, then they probably have a legal obligation to do it. So, but Melissa, you're absolutely right. It is a human rights issue. Okay, so we've got a follow-up from Flex. You're back at work. They still cannot accommodate your restrictions. Have yet to give you a plan. So, Flex, the comments I made to Melissa just now, it applies equally to you, right? There's a duty of accommodation. In your case, it's disability under the Human Rights Code. In Melissa's case, it's a different ground, right? Probably family status in Melissa's case. The duty to accommodate, it's actually a very it means the employer has to do quite a bit, right? It doesn't mean they just, they see that they have to spend a few $1,000s accommodating your injury and they don't want to do that, so they're not going to accommodate you. It's they have to kind of really work with you and talk to you about what reasonably they could do to the workplace or to your duties or to your work schedule to help you keep working, right? That really depends on what medical conditions you have and what your doctor says you can or cannot do. So if you have, some sort of, I don't know, you broke your arm or something, right? If there's a certain part of your job you cannot do, then the accommodation would be to just eliminate that part of your job, right? Or get somebody to help you with it. So Flex, I think you should talk to a lawyer. It sounds like your situation certainly warrants it. If the employer is just saying they cannot accommodate any of your restrictions, right? And a lot of times it also depends on the size of the workplace and the size of the company, right? A large multinational corporation is going to have a higher duty to accommodate someone who's disabled than, a small mom and pop shop. So, and Flex, it's going to be hard for us to talk in this forum about it, but please come talk to me, or if you're, wherever you are, come talk to one of our lawyers about it. Because they at the end of the day, if they're just saying we're not going to accommodate you, that's illegal, right? Last question by JC: if an employer never approves any requested days for vacation, and you go into next year without being able to use the days, what happens? Well, no, you have a right to use the vacation, right, JC? I mean, that's the issue is you have a right to use the vacation days you have. The employer has the right to kind of schedule that vacation according to what their needs. If you don't use it, you have to get paid out, right? If you're not allowed to use your vacation days, you have to be paid out that extra money, whatever it is, right? Depending on how many weeks of paid vacation you have in a year. And if they have a vacation policy, JC, I would look into that first, right? Because if they have a policy, they have to follow their own policy. But if you're not able to use them, that's probably illegal, and they're gonna have to pay you out for the time you didn't use. Okay. So thanks everybody for coming. That's all the time we have. I'll be back in 2 weeks, same time, Thursdays at 1 p.m. Yeah, so see everybody in 2 weeks, and I hope everybody has a great weekend.